Good afternoon. Welcome to Probate Weekly. I'm Bill Gross at Bill Gross Probate on social media or billgrossprobate.com if you want all my contact info. We do this every Thursday at 4 p.m. Pacific time, 7 p.m. Eastern, and every time in between on either side. And normally do an interview. I have a guest lined up, and I am not sure where she is. Now, obviously, we work with attorneys, and they're busy, and we want to give them time to run their business. And I also know in my neighborhood, there's a power outage here in LA. It doesn't affect me. It affects my daughter who lives just a mile away. So we'll see how she goes. Let me just kind of do some housekeeping here while we get started. Let's see here. The Probate Weekly is probateweekly.com. And let me share the screen so you can kind of see who we are and if you want to get more information. There we go. So our Facebook group is Probate Weekly as well. We have over 4,000 members. Yay, thank you for those who support it. Help us get on. But you can come here and do a couple things. You can have referrals out of the area. Look for referrals in your area for attorneys and realtors, as well as post your probate and avoiding probate, estate planning content here as well. So we can work together and get more views. Other agents here are interested, as well as vendors and attorneys and the like. So love to have you join there. Also, there's our guest. Also, hey Betty, how you doing? Let me just do some
Hi.
homework here.
Sorry, I think I clicked on the wrong thing to get on.
That's okay, you're an attorney. We all forgive you. I'm glad to have you here. For what I pay you for this appearance, I get what I pay for. So thank you. And then if you want to join in and get registered, probateweekly.com is the email. We're going to be moving our format. August 8th, we're going to move to a 9 a.m. format, and we're going to go back to Zoom so agents can participate and ask questions of our guests. Stay tuned for the details there. In the meantime, make sure you're registered. You can also scroll down and get your favorite audio formats as well as past episodes on YouTube. Really excited today to have our guest. If you follow my YouTube channel, we interviewed her about a month ago. She's fantastic, so I invited her to come back. Beti Bergman is Peninsula Law, which is now, all over California we have peninsulas, but in her case, it's the South Bay Peninsula that we're talking about, Rancho
Right.
Palos Verdes and Rolling Hills. Beti, thank you so much for joining us today.
Oh, you're very welcome. Thank you for having me. So
So,
excited to be here again.
and we talked, and I really feel like we connected. Just a couple things jump off the page when I start with you is, I noticed on your website, right below your name, probate specialist. Now, I know that realtors, we use that word a lot, or we apply words and we look for things online. You're an attorney. What does that mean if you see an attorney like you with that term or one that doesn't have the term? What does that mean to you?
Yeah, that is a great question, and it's important for the public to know. So when someone is a specialist, because you cannot use that term unless you're actually certified as a specialist in a field of law. And what you need to do to get certified in a field of law, like for example, for me, probate, trust, and estate planning, I'm a certified specialist in that field, those fields of law. You have to take a separate bar exam and pass that exam in that area of law. And you do have to have other people, other practitioners refer you or act as a reference to kind of stand up and say, yes, we know her and she does practice in this field of law and is knowledgeable and is a good practitioner. So there is a process involved to become a specialist in a field of law. You do have to apply with the state bar to get certified. And so there is a whole different, separate and apart from the regular bar, a screening process to become a certified specialist.
And I think if I could just add, as a real estate agent, when my customers have an attorney and they give the name, the first thing I do is I go to the calbar.org website, CalBar for the California Bar. Now it's different in every state, similar, but different in every state, calbar.org, I'm sorry, calbar.ca.gov. And I look up the name of the person. In this case, we're going to look up Betty, and this is where we verify that she's I already did, so it's not like there's no suspense here. But what you do is you can get their contact info. Now there's similar name, but we know this one's the right one. And it has their contact info, if it's hard to find them, their phone number, their email address in some cases, not all, website if they have one. But more about this attorney, you click down and you see certified legal specialty. And here we have estate planning, trust, probate law. And what that means is she is approved, and that standing gives her certain authority to put a logo on her website, a market material. But it's more than that. And as she said, unlike realtors, we get that logo by paying for it, typically a $200 fee, take a class, they send you the logo. In the attorney's case, to me, this is a very important distinction. And if you have a client with an attorney that doesn't have this on a probate matter or a probate litigation matter or for estate planning, man, that's a red flag. And I appreciate you explaining that to us, Betty. Give us a chance to go through that. So obviously, you're licensed. You could do all kinds of law. Just like as a
Right.
realtor, I could sell houses, vacant lots, commercial property, industrial property, the Brooklyn Bridge, I guess, or I should say the Golden Gate Bridge. How'd you end up in probate, in particular, in estate planning?
Yeah, I really, kind of a stump. I don't know if I wanted to. I was a city attorney before, and then when I had children,
Whoa, whoa. I didn't know that. Where?
in Los Angeles, in the city of Los Angeles.
Oh, wow. Okay.
Right. So that's what I was. I was a civil litigator before I became a probate attorney. And I do probate litigation, a lot of litigation in this area. But before I was a civil litigator, I was with the city attorney's office. And before that, I was with private firms. And when I had my children, I really wanted to be able to, one, have some flexibility with my time, but also I thought about how can I apply my skills to kind of help families and kind of go in that direction, because I was so family oriented at that time. My kids are now in college, so I'm a little bit more removed now. But anyway, it was just such a great area of law to immerse myself into, and it's a very, very detail oriented field of law, which is kind of how I'm wired. So I'm very good at very specific details, being very organized, and a lot of estates being accounted for, or challenging accountings for estates or trusts, defending accountings for estates or trusts. And I have 2 degrees in mathematics, so that just is really comports with my way of being. So it's just a great area of law for me to get into and specialize in. So that's kind of how I kind of came into this. I suppose if I hated it, I would have done something else, but I just love it. And I love working with families, helping families, and trying to correct a lot of wrongs that are done, that happen out there, especially against senior citizens. We do a lot of financial elder abuse, and it's great to be in work in those cases and try to protect senior citizens.
To be precise, you litigate against elder abuse. You don't actually do.
Right. We don't do elder abuse. We don't commit elder abuse. Yeah, we try to protect.
You probably be really good at it if you decide to turn to the dark side, but just a little slip there. Okay. So I think, and one of the things you point out there, I think, is that you must therefore have, I think, really a combination of 2 opposite skills. There's the soft skills of wanting to work with families and working with families, and there's the more technical skills of, in your case, math as well as law. So how do you balance those 2? I mean, I had the same challenge myself. I deal with attorneys and filings and petitions and numbers and contracts, and then I talk to somebody who just lost their parent and be sensitive and understanding to their needs. How do you balance those 2 kind of seemingly conflicting sides of yourself?
Yeah, that's so interesting, and I don't feel like it's conflicting, because it's really. I don't feel like I need to try to do either ends of those things. I think one of the things that made me successful is working with people and being able to understand people and listening. And this is other people, but colleagues have told me this before too. Listening to people, just, I think people have a lot of conversations and dialogues with people, but they don't really catch all the details, and they don't really listen that well. Sometimes they're just waiting to, for their turn to talk and be able to say something. I somehow have a knack of being able to listen very, very well. So I think it's easy for clients to work with me, because I hear their stories, I can relate to them, and then I can go do the work, and that's all the detail oriented and things that come into play there, and just working up their case, and also continuing that communication. That's also important too.
What percentage of your time is building the barn and getting cows in the barn to keep them safe, i.e. estate planning and trusts, versus cows get out of the barn, trying to round them up and figure out who's responsible, i.e. probate litigation and probate administration. What percentage would you say your business is kind of pre-need, and what percentage of it is kind of post-need?
Yeah, I think just because of the nature of the beast of litigation, that consumes most of my time. Because once you get into litigation, it's very consuming. So I would have to say the majority of our time is spent on litigation cases because of the nature of those kind of cases. But we do the planning and we do the administration too. So it may go in the order of time consumed or energy spent in these cases. Probably litigation is number one, administration is number two, and planning is number three. Now, that is not to say that planning should not have good time devoted to it. I always say, because people probably think litigation is very difficult. It is. It's very stressful. It's very adversarial. It's time consuming. However, planning, I think, is probably the hardest thing that we do in our office because it has a huge area of law behind it. And I think people who don't appreciate how estate planning goes, they may just kind of pull out forms and say, okay, who do you want to have as your beneficiaries? Who do you want to give your house to? That kind of thing. And it's just simply not that simple. That universal law behind estate planning is huge, and it needs to be kept up with. And tax laws and tax consequences of estate planning also need to be kept up with. That changes almost every year. And so even though if the majority of our plans are pretty basic, the counseling and the advising with those clients when they come in is really, really important. And then how to draft that estate plan according to what the current laws are is very important. And that I'm always saying that is the hardest thing we do. It cannot be a simple form that you're pulling out and saying, okay, who do you want to give the house to? That and if that's all that someone is hearing from their estate planning attorney, you may want to go get a second opinion.
So, and I appreciate that. And I think that for too many, it is just a simple form, and then they find out there's a problem later.
Yeah.
I think that, I find attorneys, fit two categories. One who only do estate planning, i.e., well, everything's easy. And there's other ones that do the planning, also do administration, and do litigation because they want to have a more holistic perspective. Personally, I always find I learn more from attorneys who do both because I feel like if you see what you're litigating, you're going to prevent that in your planning, and I think that gives you more insight than those who just simply fill out the forms. So that said, what is the one or two most common preventable things in plans that you end up litigating on regularly? What do you see as a more common, man, if they had just done this 5 years ago, they would have saved hundreds of thousands of dollars or all kinds of agony? What are two most common preventable issues that you see?
Yeah, probably one, keeping it updated, because estate plans, like I could just kind of mention, the laws change, and people's circumstances change, their families change. People that they have named in their estate plan when they first created it may not be even around to be the trustee or even to be a beneficiary. So one is to keep it updated, but a lot of things that I see is, and this probably maybe goes back to the listing or something, or just you shouldn't use just a form, because what I see sometimes is that the wishes aren't really spelled out properly in the trust or the will. It's kind of like, someone had a template and then they kind of put that in, and the person comes in later and says, this is not even what I wanted. This is not what it says. So it's not really, I think it's not probably listening to that client to hear exactly how they wanted things distributed or things done. That comes up a lot, where I said, well, this is what the trust says. That's not what you're saying to me. And they're saying, no, that's what we wanted, but it doesn't say what they want. So I think that does come up enough where I think, whoever is doing the plan did not sit down and really listen to this person's story and their family dynamics and how they really wanted things done. And it was more like kind of filling in blanks. I think that happens, enough. I've seen that enough, and heard it from clients enough. So that does come up. Another thing that kind of comes up is, this is totally up to the clients. I was going to say that co-trustees get named to act together because parents may think, oh, my kids will all get along and they can act together as trustees. And that is usually the majority of the time, that does not work. That does not work. Now, if the clients insist upon that and they think that, they say this is what they want, 100%, that's how you should write it, because really you're there to carry out and draft the client's wishes. But they just need to be fully advised of the consequences and what could go wrong if they do something like that. So sometimes I see that, the kids don't get along. There's no way. Someone needs to get removed, and there we are filing a petition to remove a trustee because they took off with a lot of the money, spending it, not telling the other trustee. That happens a lot.
They didn't get along as siblings sharing a bedroom when they were teenagers. They're not going to get along managing a multi-million-dollar estate 50 years later, I think.
Right.
That's a pretty common case. So, So obviously planning ahead and kind of foreseeing those issues is a major part. One of the things that I see regularly as a real estate agent, probably this is where I get involved more often, is an estate plan is started but not completed. Most commonly, I have an estate now, it's in probate, so everything's public. I can talk a little bit about it. It's a $40 million estate where he went to an estate planner and he got a great binder and it has everything laid out that he wanted. He never signed it. Now maybe he wanted to make revisions and we don't know exactly the status. Maybe he had regrets and didn't want to, who knows? But at the end of the day, legally, it's interesting information. It's valuable of sorts, but it's not legally binding. We're in probate court spending a fortune on attorney's fees and legal fees.
Yeah.
So I'm sure you commonly see plans that don't get finished, plans that don't get executed. How common is that? And what are your best tips to help avoid that for somebody who comes to you as a estate planning client?
Yeah, to of course to follow up and see, to finish this off, because that does tend to happen. And again, compared to litigation that we do, where litigation runs very, very fast, and there's deadlines, there's court deadlines and things like that. Where estate plans, there's no deadline really. It's kind of, you meet with the client, you draft it. You usually give them, we do anyway, give them the drafts to make sure that they review it and it says what they wanted to say. And it very commonly, the clients want to think about it some more. And it's very easy for that to drag on and not get done because there's no hard deadline to have it done. We always have like a checklist, a timeline, like when did we first meet with the client? When did the drafts get sent out? When are we going to meet with them again? When are they going to come in and sign it? Whatever. And so we follow up on that. So we try to make sure that does not happen, but it could happen. Yeah, sometimes clients may change their mind, or they just, this happens too, where the clients they're trying to think of who to give their estate to, and they don't want to offend people, so they don't want to finally conclude that, okay, these are going to be the beneficiaries and this is how much people are going to get. And so they kind of drag it out because they don't want to commit to that, because they think I'm going to offend someone else by giving these kinds of gifts. And those kind of people, completely understandable. But you got to remember, like during their life, it is amendable. It's a revocable living trust, meaning you can amend it. So if they have second thought, they can always come back and amend it and change the beneficiaries. But the important thing is to make sure, for the practitioner to, keep it moving along and don't let it lapse because the client's not getting back to you. Now, if the client doesn't want to finish it, I would suggest to a practitioner, okay, make sure you cover, write a letter confirming you do not, you purposely did not want to finish this. Now, another thing that comes to mind that happens is people don't fund their trust properly. That's a big thing.
Before we go there, that's another topic. Let's finish up on the finish part. And for those of us listening, if you're a real estate agent, I really promote we should be actively supporting our customers in getting a plan done. And to me, that means following through. And so oftentimes I'll refer, a client to an estate planning firm, and I'll follow up with them. Hey, did you get it done yet? Because I know getting it done with real estate means the deed. We're going to talk about funding.
Yeah.
But I want to make sure it gets done, not because I get paid. I don't get paid anything for the referral. I get paid in heaven because I help somebody avoid those problems and the job is done. And I see people don't. So I think for those of you listening, as real estate agents, I think we should feel comfortable when we make a reduction to a firm. We should make sure in our database, call back 3 days later. Hey, Joe, I know you were going to meet with Betty. Did you guys ever get together? Great. Did you finish the plan? And, you want to know that happened to make sure it gets done, because as long as you're helping the customer and you're helping the attorney, that's part of being service. We're not following up for our own invasions of privacy purposes or own purposes. So that leads naturally to the next question. I'm sorry to interrupt you, but I want to make that sales pitch to my listeners that we should be active in part of the solution, not just part of the problem, is funding the plan. So go ahead and explain. The other problem people commonly have is they don't fund the plan. What does that mean?
That's right. So for a trust to hold assets, you need to declare those assets to be held in trust, which usually a trust has that language. And usually, hopefully, that's another thing I find sometimes. I was just going to say, usually there's a schedule of assets to be held in that trust. So it's attached to the back of the trust, listing like the houses, the bank accounts, things like that, saying everything on Schedule A, we're holding in this trust. And we hereby transfer these assets to the trust. That's what the first step. Now, I do see trusts where it says, okay, everything on the schedule is we're going to hold in trust. And there's no schedule. That happens several times. I think, well, where's the schedule? What happened? What's in this trust? We don't even know what they meant to have in the trust. But so one is to declare the assets in the trust that way. The other thing is to actually retitle the assets into the trust. So if it's a bank account and it's under, Joe Smith, you want to now transfer it under the title Joe Smith as trustee of the Joe Smith Trust. So each asset you do want to retitle it under the name of the trust. So this is the funding. That's funding it. Real property, yes, you have to have a deed. So it's going to be Joe Smith as a single man, as a sole and separate property. Maybe that's how he holds title. Then you're going to have to deed that property from Joe Smith as a single man, as a sole and separate property, to Joe Smith as trustee of the Joe Smith Trust. So that deed needs to be prepared, signed, notarized, and then recorded with the county where the property is in. So that's how to properly fund your trust. So you want to make sure that it's, in the trust schedule and also titled in the trust.
Great explanation. I try to tell customers not putting the property in the trust is like buying a safe deposit box for your valuable gold collection, but you put the safe in the closet, but you don't put the gold bars in the safe and close the door. You really haven't accomplished much, right? And as realtors, I want to say we should be comfortable helping our customers make sure it gets done. The property is public record. We should all have access, we do as realtors, to public records, and we can verify 30 days later, yes, it was recorded in the trust. Here's a copy for your record. Send it to the attorney, send it to the customer, send it to whoever would benefit from it. It's public record information to make sure the customer does it, because if they don't do that step, Betty, how many times have you seen a customer come into your office with a beautiful binder and a beautiful deed from the person to the trust, and it's right there, it may be executed, but was never recorded? How often have you seen that happen?
That does come up every now and then. Usually, if there's a deed, it does get recorded. Now, remember, a deed legally actually does not need to be recorded to actually transfer title, but that is to give constructive public notice that the titling, the ownership of that real property. So the deed is good as long as it is signed. So that's very important to know. But usually it will get recorded. More often I will see that it never got done. It just, that there was no deed or whatever, that just never got funded into the real property, never got funded into the trust. So that happens. Sometimes I'll see that it didn't get, the titling is still not wrong, even though a deed got done. Like they didn't write it into the name of the trustee and the name of the trust correctly. That kind of comes up. And then you're trying to fix that or correct a deed. Sometimes you have to do that.
So again, and those are potential fails, or sometimes the attorney can fix it. That it's important. The best case, if you put the money together and the time to build a plan, get the deed, get it signed and executed, get it recorded. That way you've finish the work of protecting yourself. I think that's so important. Okay, so obviously now you have a customer who has a plan, and like a lot of us, I go in public records and I see, oh, they own a property in the name of the trust, and that's great. And they've had nothing recorded since 2002, or it says right in there the 2002 trust, the trust dated blank blank 2002. How often should somebody have it updated? If they're, husband, wife, fairly simple life. In my case, my only child's grown up for a while now. We own a house. How often should they look at? How often does the law change that some of those powers I thought I had when I did the plan 10, 12 years ago may not be available today?
Yeah, I would say a good rule of thumb is at least 3 years. Review it and update it and take a look at it. We offer on plans that we prepare, we offer free reviews every 3 years because I really don't want any estate plans that we prepare to be outdated out there. So that's what we offer. But for people that have their own estate plans, you should, take a look at it every few years. Our rule of thumb is just 3 years, but, certainly don't wait till 10 years, because laws really just change, within 10 years, there's definitely laws that have changed and things like that. So you really should just, and nobody wants to do that. I understand it's probably to a lay person, like a life insurance policy. You don't want to take that down and read it, right? But at least take a look at the key provisions, like who did you name as trustees? Who did you name as your beneficiaries, and what gifts did you make to these beneficiaries? And what assets do you have in the trust? I'm sure your assets change over time too. So those are like key parts of your trust that you really should visit. You don't have to look at all the boilerplate, the rest of it necessarily, but take a look at those provisions and then go visit your estate planner to go and revisit that and see if everything's still up to date and if you want to change everything. Because you really don't. Yeah. So that's another thing that you find after death is like, okay, this never got updated. There's a trust that never got updated. These people are not even around anymore. These assets are around. And then we're trying to find like what assets did they have at death? And the administrator or the trustee is, looking for these things.
I did one of these interviews about a year ago, and the attorney talked about updated assets, and I was talking about my plan. I pointed kind of to it, and also I said to myself, hold it, we just changed banks like a year ago.
Yeah.
I didn't do it in the trust. I didn't even think about that. Of course it should be in the trust. And and then I realized we have some other assets that should be on the addendum, even though technically I took title as a trust. It's extra safe to update the addendum that has, the updated assets. And so I realized, here I'm talking about how important it is to update it, and I wasn't even. I'm a cobbler with my own kids don't have shoes, so that's definitely a problem.
I know that's easy to do. It's really easy, I can't say that I'm not guilty of that myself, because if I do this all day long, I don't want to go look at my own thing. But the rule out there: do as we say, not as we do. Go and make sure your estate plan is updated.
Beti, I give great marital advice. I've been married 38 years, one day at a time, hanging on by my fingernails. And I give men great marriage advice every day. I don't follow it. I don't even do any of it, but I'm really good at giving the advice. So
right.
We'll see. So let's switch a little bit to the business side, to the Beti Bergman, entrepreneur, businesswoman who runs a business. Obviously, you're an attorney. You have customers you give service to. You have staff that you have to manage and oversee, and then at some point, you have to develop business. Now, you have a obvious reputation being in the area for quite a while. Do you still do business development? And if so, what percentage of your time do you spend on developing new business, and what kinds of things that you do?
I'm gonna knock on wood and be very grateful, count my blessings that I really gotten to a point where I don't do any marketing necessarily or go out and generate business. Now, having said that, I just happen to be very, very active in my community. So I'm, on maybe some boards. I'm part of different groups. I do that just because I just like to keep connected with the community, other practitioners, and they've all become friends of mine. And so I am involved in the community a lot. And that is only because, really, I've just become friends with the people that I'm involved at these organizations with, and so I like getting together with them. And what percentage of my business comes from that? I would say like I do get business from that. And that's really not even the purpose of me being part of these organizations. I just like being connected. I like giving back to the community. I like just being part of the community. So I do that, and I probably do get business from that. But let's say if I stopped all that, I mean, I don't think I don't think my business would necessarily die. Hopefully not. But yeah, I think it's just luckily has come from the fact that I've, maybe my reputation is known, people know me, and I get referrals from clients, other, colleagues and things like that.
So if you had a family member that was looking to get into probate real estate and their goal was to be of service to probate attorneys, not to be a cold caller, obviously, or a, direct mail, billboards, all that nonsense, but really wanted to learn how to be more effective and support attorneys in exchange for that and earn some business, what would you recommend activities for realtors to do? And what are some of the things you've seen real estate agents do that you would recommend them not to do?
Yeah, well, that's interesting because I do have a realtor friend who I did bring into, local bar organization, and he just, he will say this to this day, like he's so grateful for that because it really opened up his whole business and got him connected with so many people in the community. So I would suggest, getting involved in your local bar organizations, local boards and things like that. And you really get connected with a lot of people that way. And it's very important to always keep in front of, like, let's say if you want to, get the probate sales from probate attorneys, it's, because there's so many people like that. There's so many realtors that really solicit, I get calls from realtors, emails from realtors all the time. And I'm sure a lot of other probate attorneys get that as well. And you just got to keep that constant connection and be in front of people's faces. Otherwise, it's so easy either to forget that person or someone else is very actively in front of them. And so when the probate attorney is thinking, okay, I need someone to do the sale, and I've been in recent communications with this person, that person's just on their mind. And so it's easy just to turn to that person. So the realty game, you really need to be out there always in front of people's faces. So you're on people's minds. They don't forget you.
So for our listeners, just to expand what she's saying, you don't have to be a member, you have to be an attorney to go to bar association events. Most bar associations, which is a term for a legal group. I don't mean a bar is in your local pub. I mean a bar is in
right.
Where attorneys gather. Almost every local area has a bar association. In LA, we have downtown LA, we have Century City, Beverly Hills. And I think they all will have memberships, or most have memberships for affiliates, just like we as realtors have affiliate memberships in our groups for mortgage people, title, escrow. So does the bar association. And I think it's important to go there to learn more and to network more than it is to take down somebody there for their business. The mistake I see are agents running around with business cards, really soliciting. And the attorneys are usually there for education. They're usually there for networking, referrals from other attorneys. And I will give an example. I went to a bar association event, and one of the local attorneys who's really very well known gave a great talk on Hegstead petitions. And by listening and paying attention, and they had handouts, the next time I had a customer called me who said, hey, I have this case where it was supposed to be a trust, but the deed wasn't put in or was taken out for refinance, wasn't put back. I said, hey, that sounds like a Hegstead petition. And I had the forms and I had an attorney to refer him to and got a listing as a result of that. So I think the opportunity for realtors is go there to learn as well, and also find attorneys that you can maybe befriend and can be a resource for you. We can ask them questions and learn about probate and then be of service to them with things that they need. So thanks for pointing that out, but I think it's a good point that in our industry, we always talk about cold calling attorneys. I say, well, don't do that. Nobody wants to be that person, but be the person who shows up and helps out.
Right. And that's such a good point, Bill, because if you go to a probate attorney, if you're just having a conversation with a probate attorney and you start talking about something like Hegstead petitions or things like that, they will, well, to me anyway, I would remember, oh, okay, this is a knowledgeable realtor and he knows about, kind of the probate machinations and how to deal with probate sales or transferring probate properties, things like that. So if you say things like that, and that would just kind of alert a probate attorney like, oh, this person's knowledgeable. So you're very, very right. So a lot of these organizations, they always have education. There's always speakers at it, things like that. And you learn a lot from those organizations and the seminars that they put on. And so that is key. And I always say too, like, and I've never been in sales or anything, but I've heard this from other people that are more have a sales role in their professions. But, business is like, it's all about relationships. It's not like, oh yeah, exactly, like cold calling and trying to just cold call someone. I don't think that's going to get your foot in the door. That's not going to get you that far. It's all about building relationships with other people. And once you have that relationship, get some loyal relationships going, you're golden.
So the best marriage advice I got was when I got married. Not that I follow it, I know it, and I talk about it a lot, but I've been married 38 years, one day at a time. The advice was the key to marriage, and I think business, is not finding the right partner, it's being the right partner. And I think in a relationship, as you want to do business with a real estate agent or with an attorney, you want to be the realtor that attorney wants to work with. Well, what does that mean? Be pleasant, be nice, be helpful, be productive, be valuable. Help them with their business, and they'll have to use you going forward. So Audra asked a question, which I think is great, which is any bar association events coming up soon? And the answer is, Audra, depends on where you are.
Right.
There's bar associations, and then more importantly, many of the larger bars have chapters for groups. Like we mentioned in the beginning, that Betty is a specialist in estate planning and probate. Many of the bar associations have a trust and estates department or a real estate department. And frankly, I would go because I want to learn the content myself. I've gone and learned so much in LA in particular, because we have so many bar associations. We also have the LA Law Library, which has classes both online and downtown LA. Great resources to learn about the business. But I'm not sure, Audra, where you do business. You're in Los Angeles, but it's a big market, LA. There's Santa Monica, Beverly Hills, Century City, downtown.
Right.
Betty, you're in the South Bay, or which association do you participate with?
So that South Bay bar, there's a South Bay bar down here.
There's a Valley Bar. There's, I'm sure there's more than that. So all over LA, look it up. Just do a Google search in your area. Yeah. And again, many of them have, most of them have, excuse me, affiliate relationships where you can join as a member, get a discount on the fees, be in the roster. You can sponsor events if that's how you want to go with that. So definitely I would go.
Right.
Yeah.
And there's an overall LA County bar too. So that kind of encompasses it. So I'm part of the executive committee for trusted estates on the LA County bar. And so that's the main LA County bar. And then there's all the local ones like you mentioned. So and so you want to really kind of get involved in probably in your local area so you can get to know the people around you.
One thing I did was the LA County Bar had online especially with COVID, with all the judges, and the judges would explain the probate procedures they wanted. I just went online and took notes, and then shared my notes with all the attorneys that I had met along the way. And nothing says you're the right person than showing them that you're paying attention, you're learning, trying to help them do their job better. So it's really important, I think, to be the right partner. And one way is to go to those events. Okay, so. Matthew Price, do most bars offer a non-attorney vendor type relationship? Matthew, the answer is yes, most do, but not all do. And it's one of those things where it varies, but some are free, some charge amount of money, some give you a discount if you're not a member of the bar. So I would say it just depends on which ones you deal. I'm a member of the National Bar Association's affiliate. I get the National Bar Journal month magazine, and I also get the Trust subset, which is interesting as well. So again, each area is different, each state's different, each county's different. So, okay, good. So let's see. I want to ask you next question. So obviously, we deal in very volatile times business-wise. Things change. COVID, we were shut down. I think in where you are, the South Bay wasn't as shut down as we were in LA. Just general tensions. You have economics, you have politics. What percentage of your business did it change on dealing in person in your office versus online? What percentage of customers actually come to you, sit down with you, sign the book with you, versus do you handle things online?
It's almost It's almost half and half, I think. Certainly during the COVID time, we did everything on Zoom, and all the court appearances still are remote. You can go in person. Well, you got to go in person for trials, but regular appearances, we're doing that remotely. When we meet with clients or even do consultations and things like that, right now it's almost half and half because we're meeting with people in person. Some people just want to meet in person. They feel better, especially if you have more kind of older people. They just really prefer coming in and meeting in person instead of doing it on Zoom or something else, some sort of video call. So it's yeah. So we get both, and because we do serve some senior citizens and things like that. I find like they are much more comfortable coming in person. So it's half and half,
So there
I
still
think.
is that in-person element, and that you offer that. I think that's important, and I think for
Mhm.
all of us, it's about you have to make decisions how you want to run your business and understand those costs. Personally, usually if a customer has to meet with me, I'll bring in a partner and refer it out just because it's more efficient for me to work from my home office. I know some
Mhm.
attorneys prefer that too, and yet others work in an office location. And you're located, I think, in Torrance or Palos Verdes.
I am in Torrance on Sepulveda, right across from the Madrona Marsh here.
Yeah.
And yeah, and I work from home sometimes, but I happen to own my office, so I might as well use it.
Right.
I have people here, so like I feel like I kind of need to be here to answer questions. I mean, although if I am at home, I will talk to them on video like this. But since it's almost half and half in person meetings and Zoom meetings, so oftentimes I am coming in here because I have in-person meetings.
Now, of late, we've had some drama at the LA County Court. How's that
Mhm.
affected you the last couple of days, and where's that headed, do you think?
Yeah, gosh, that was really something. Yeah, so that happened, I think, June 19th, maybe, or July 19th. So the system, so the people who don't know out there, the court system was shut down because they were victims of ransomware. And so you couldn't file anything. Nobody could do their remote appearances because all the systems were just shut down. It is opening up now. So now I think it's kind of back up, but I'm not even 100% sure about my next court appearance if I could do it remotely. But it was frustrating because I was trying to get something filed and we want to get something served on someone, and we couldn't do it because it was just shut down. We got it filed, but it didn't come back from the court yet because they couldn't do anything. So I was just holding my breath there, and that finally went through. I think the last couple of days, yeah. So
I think it's still expanding. They still have limited services that are not available, and it's been a dramatic couple of days. And I think it's interesting how dependent business-wise we are now. Years ago, electronic filing was such a nice opportunity when you wanted to use it, and now you have to if you're an attorney. And
right,
remote appearances was so nice during COVID, but now we're all kind of addicted to it for court appearances. And it's just an interesting reminder about the business. For those of you not following, a little drama, the entire LA County court system was shut down for a few days, and even now is still kind of reeling from the effects of it. So we'll see how it goes.
right.
Well, look, Betty, I really appreciate you taking time today to share with us, in particular, explaining about certification, explaining about the importance of getting good estate planning ahead of time. I really appreciate your help overall. I know your website is peninsulalaw.com, peninsulalaw.com, and on there, a nice picture of you. Is that the best way to get in touch with you? How should somebody who wants to learn?
Yeah, through that, and it gets routed through me if you want to have a meeting with me or anything like that. You really should go through my secretary and the main line, because I can't get to all my emails and calls and everything. So someone needs to get in front of my face. They got to go through the channel of my secretary. So
Well, again, thank you so much. I appreciate your time today. And anybody interested in estate planning or probate administration or probate litigation, she's obviously a very accomplished litigator. Beti Bergman, thank you for joining us today. I really appreciate it.
oh, my pleasure. Thank you so much for having me.
And for the rest of you, this is Probate Weekly. We do this every Thursday at 4 p.m. Pacific time, 7 p.m. Eastern time, and every time in between and on either side of it. We have a Facebook group with over 4,000 members. So if you're looking to refer out leads, listings, attorney needs and such, go on the Facebook group. If you have probate-related content or estate planning content, put there to help you get more eyeballs, more views, more subscribes, and all that good stuff. If you want to join regularly, probateweekly.com is the place to go. You're going to want to make sure you're subscribed because we're going to be moving over to a new time. It's going to be 9 a.m., not next week, but on August 8th. And we're going to have a Zoom format so we have more interaction with agents and a chance to talk to the guests directly. If you're interested, go to probateweekly.com, scroll down. You can subscribe in your favorite audio formats, as well as see past episodes on youtube.com. So again, thank you to our guest today, Beti Bergman, who's an attorney in Torrance in the South Bay of Los Angeles County. Appreciate you guys. Beti, thank you so much again. Have a great week, everybody. Thank you so much.